Good morning, or good afternoon, rather, ladies and gentlemen. Welcome to Bexar County Court of Law number 6 and the Bexar County Veterans Treatment Court. Today we have plea docket and motion to revoke probation docket. And I believe we have one pretrial motion that we'll discuss shortly. The cases I have set for pleas are cause 644-755, State of Texas versus Jaime Roberto Martinez, represented by Mr. Joseph Statson. Cause 655-321, State of Texas versus Noe Rodriguez, represented by Mr. Dirk Ashbaugh. Cause 641110, State of Texas versus Oscar Marmea, represented by Mr. Michael Goins. Cause 646-357, State of Texas versus Michael Chow, represented by Mr. Jeffrey Hole. I have motions to revoke probation. Cause 584901, State of Texas versus John Garcia. Cause 624186. State of Texas versus Sonny Macias, cause 628236, State of Texas versus Luis Cedillo. And then our pretrial motion is cause 389841, State of Texas versus Blanca Aleman, represented by Miss Julie Pollock. My understanding is Mr. Martinez is going to need an interpreter, and Miss Pollock will need an interpreter for her client also. So I apologize, the interpreter, we're gonna get you out of here as soon as possible, but it may take a while today. Mr. Statson, is Mr. Martinez ready at this time, or are you waiting on him? What are y'all doing?
Joanne's office is on the phone with him. He had a mix up with the time. We're trying to get him on Zoom. We're trying to do that right now.
Okay.
But may I ask, does he have to have video enabled or just audio is fine?
We've seen him before. We know who he is. If you know who he is, if the state doesn't object, it's okay with me, but it's up to the state.
Okay, let me try to get him on audio right now. I apologize.
A video if we can get it. But just let us know when you're ready. And in the meantime, we'll take up some other cases and we'll just be in that process, okay?
Yes.
Your Honor, please remember to enable the English, the interpretation.
We're not doing that right now, correct?
Okay.
I don't need to do that until we need an interpreter.
Okay.
Okay, when we start getting into the pleas, representing the state is Mr. Nicholas Maru and Ms. Alexis O'Connor. Representing the Bexar County CSCD is Ms. Susan Gross, who I will swear at this time. Ms. Gross, please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Okay, let's start off with cause 655-321, State of Texas versus Noe Rodriguez, represented by Mr. Dirk Ashbaugh, and cause 641110, State of Texas, I'm sorry, excuse me, cause 646-357, State of Texas versus Michael Chow, represented by Mr. Jeffrey Hole. Mr. Ashbaugh, are you ready to proceed at this time?
Yes, Judge, I am. My client is down there, his iPhone. He has got a kind of a strange job, Judge. He puts up signs, and I can't tell if he's kind of glitchy, but we're going to try to proceed. I think we can. I just like for him to talk to see if we can hear him.
Okay, Mr. Is it Mr. or Mr. Rodriguez? Mr. Rodriguez?
Yes, Judge.
Mr. Rodriguez, can you hear us, sir?
He was there a minute ago and it looked kind of glitchy. I told him to try to find a better signal.
Yeah.
Did you have a picture of him a minute ago also, or just audio?
Yeah.
We had a picture.
Like I said, Judge, he said that he's kind of out near Austin somewhere putting up a sign outside. So he's getting kind of some bad signal, I think.
Right now, you don't see him on the screen anywhere, right? So we've lost him in some capacity?
Yeah, we've lost his picture. Here he's vocal now, I think.
Oh, there he is.
There
Hey.
he is.
Hey, Mr. Rodriguez, can you hear me, sir?
Yes.
Thank you. We're going to proceed here in a moment. And if you have any questions, just stop us and ask a question, okay?
Yes, sir.
All right. Once again, this is cause 655-321, State of Texas versus Noe Rodriguez, represented by Mr. Dirk Ashbaugh, and cause 646-357, State of Texas versus Michael Chow, represented by Mr. Jeffrey Hole. Mr. Hole, are you ready to proceed at this time?
Yes, Your Honor. My client is present as well.
All good. Okay. Mr. Rodriguez and Mr. Chow and their attorneys. At this point in time, I need you to identify your signatures on a document for me. The document is entitled Defendant's Consent to Plea by Video Conference. And Mr. Rodriguez, is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Ashbaugh is attorney for Mr. Rodriguez. Is this your signature on this document also?
Yes, Judge.
Thank you. Next case is 646-357. Mr. Chow, is this your signature on this document, sir?
Michael, take yourself off mute.
Is Mr. Chow still with us? I see. Mr. Chow, there you go.
Yes, sir. That's my signature.
Very much. I do that all the time, by the way. So I feel much better now that other people are doing it. Oh, this is on this document, sir.
Yes, sir.
Okay. And now, Mr. Rodriguez and Mr. Chow, I'm going to ask you about your signatures on a document entitled Defendant's Waiver of Constitutional Rights and Court's Admonition. Mr. Rodriguez, is this your signature on this document, sir?
Yes, sir.
You and Mr. Chow, is this your signature on this document, sir?
Yes, sir. That is my John Hancock.
Thank you. Mr. Chow and Mr. Rodriguez, signing this document, are you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorneys. So that in signing these documents, you're telling me that you agree with and understand everything on these documents. Is that correct, Mr. Rodriguez?
Yes, sir.
Mr. Chow, can you hear me, sir?
Yes, sir. Yes, sir.
On this document also, sir.
Yes, sir.
All right, thank you very much. By signing these documents, are each of you telling me that you've had enough time to read these documents or have them read to you in their entirety? If you had any questions about what was on these documents, those questions were answered to your satisfaction by your attorney. So that in signing these documents, you're telling me that you agree with and understand everything on these documents. I'm doing this again. Mr. Rodriguez, is that correct? Mr. Rodriguez, is that correct, sir?
Yes, sir.
Is that correct, Mr. Chow?
Yes, sir.
Thank you. Attorney for Mr. Rodriguez. Mr. Dashbow, have you had enough time to go over this case with him? And in your opinion, is he mentally competent?
Yes.
Same question for attorney for Mr. Chow, Mr. Holt.
Yes, sir.
Okay.
Yeah. Yes, Your Honor.
Mr. Rodriguez, are you a United States citizen, sir?
Yes, sir.
Chow, are you a United States citizen?
Yes, sir.
Thank you. Attorney for Mr. Rodriguez, Mr. Ashbow. Has the state fully complied with discovery for you on this case?
Yes, Judge.
Same question for attorney for Mr. Chow, Mr. Holt.
Yes, Your Honor.
Oh, yes, Your Honor.
45 minutes, 50 minutes to give our order. And four, I think, card pizzas, 3 sets of wings, like 2 or 3 orders of bread too. Fucking name after name after name. Fucking single pizza.
Okay, you have a motion in Mr. Rodriguez case.
Time we were there and actually started meeting with our
Hey, Noe, mute your phone when you're not talking.
Hey, Mr. State, either one of y'all that are participating in this, can call 655-321 State of Texas versus Noe Luis Rodriguez. I'm looking at his plea document and it says DWI first, although on the other document it says DWI greater than 1.5 and it says we're going to do a JSAT. That makes sense?
Yeah, Judge, it's a JSAT.
All right, is it going to be a plea to DWI greater than 1.5 or DWI? What is it originally filed as?
Judge, it's originally filed as a .15, I believe. Are we talking about Mr. Garcia?
No, Mr. Rodriguez.
Mr. Rodriguez. 1 second, Judge.
Sure. Hey, Mr. Ashcroft, can you hear me, sir?
I'm sorry, Judge, I couldn't hear you. You're breaking out a little bit.
Sure.
Yes, Judge. It's originally filed as a DWI .15 or higher. The state is moving to waive the enhancement and proceed as a DWI first.
All right, so the state is going to waive the enhancement. Is that correct?
Correct, Judge.
Yes,
Right.
Judge.
Thank you. Defense, state's waiver of the 1.5 or higher enhancement is granted. Therefore, Mr. Rodriguez is charged of driving while intoxicated. First offense. How do you plead, sir?
Guilty.
Is there an agreement for Mr. Rodriguez?
Yes, Judge. It's going to be 2 days, Bexar County Jail, $200 fine, court cost, credit for time served, time and money to run concurrent, and we ask this be a JSAT. This is per a felony agreement, Judge.
And I apologize, I missed the fine amount. Was it 200?
200, Judge.
Got it. And defense, is that your understanding of the agreement?
It is.
Mr. Rodriguez, in clause 655321, the court accepts your plea of guilty to the offense of driving while intoxicated. First offense, I find you guilty. I assess 2 days in the Bexar County Jail, a $200 fine plus court costs, credit for time served, time and money to run concurrent, judgment satisfied. Anything further from the state of the defense on Mr. Rodriguez?
No, Judge.
Let Mr. Rodriguez, thank you,
That's
Mr.
enough, Judge.
Okay. Mr. Chow, to the charge of driving while intoxicated, second offense. How do you plead, sir?
Guilty.
You're in agreement with Mr. Chow?
Yes, Judge. It is 1/1, a $500 fine plus court costs, 36 hours community service, DWI intervention, DIP, CATSNP, Smart Start Mobile for half the term, and restitution, if any, to Jeanette Williams and Larry Williams.
And defense, is that your understanding of the agreement?
It is, Judge. And just to clarify, is there a specific number of restitution that he's going to have to pay?
They have two individuals, a Jeanette Williams and a Larry Williams. State, you want to answer the question?
Looking at restitution on this case?
Defense counsel is asking specifically who his client has to pay restitution to and what for, I guess. Is that correct, defense?
I was just trying to confirm for my client what the amount was of restitution.
I don't know if a dollar amount has been determined at this time.
Dollar amount hasn't been determined. What'll happen is probation will reach out to them and with written letters, their addresses, and ask them if they have any documents or anything like that. And then if it ends up being a point to where something's in dispute about the cost of something, we can hold a restitution hearing and go from there.
Okay, did you hear that, Mr. Chow?
Yeah.
Okay.
All right. Is that your understanding of the agreement, Mr. Ho?
Yes, Your Honor.
Okay. Mr. Chow, on clause 64357, the court accepts your plea of guilty. I find you guilty. I assess 1 year in the Bexar County Jail, probated for 1 year, $500 fine plus court costs, 36 hours of community service, DWI intervention course, DWI victim impact panel, community lines for traffic safety, new intervention program, outpatient drug, Smart Start mobile home interlock for 6 months. Restitution, if any, to Jeanette or Larry Williams, and/or I guess would be to say that, if any. And once again, as the state has already stated, if the amount comes back and the defense doesn't agree to it, we'll have a hearing on the amount and a restitution hearing, basically.
I thought you were gonna waive the drug class.
Michael, it's not in there.
Okay.
I think DOEP is the drug class. We're not finding that. You're going to just basic outpatient drug course, which covers everything with the Community Alliance for Traffic Safety.
Okay.
Got any other questions, sir?
No, sir.
All right, Pat, you want to talk to him about probation? Or Susan?
Mr. Chow.
Yes, ma'am.
You will be receiving either a telephone call or an email from the probation department within the next 48 hours instructing you on when your orientation is going to be.
Yes, ma'am.
Okay. If you do not hear from them, I'm going to give you a telephone number to call.
Okay.
It's 210
Mm-hmm.
335
35.
210-335 7446.
210-335 7446.
Yes, and you're going to ask for intake. Explain to them that you were placed on probation today,
Yes, ma'am.
and you need to find out when your orientation is. Now, that's if you haven't heard from them by Friday afternoon, then call them on Monday morning about 10 o'clock.
Okay.
Okay, it's your responsibility to make sure that these documents get signed. Otherwise,
Oh,
you'll
yeah.
have to right
Yes,
back
ma'am.
here. Okay.
So if they don't call me by Friday, call them on Monday. Correct?
Yes.
All right. Thank you.
All right. Good luck to you.
Thank you so much.
Mr. Statson, have you been able to contact Mr. Martinez?
Yes, he is attempting to dial in. He'll have audio only.
So right now we have audio with him.
He's dialing in. He should be joining momentarily.
State, I don't have a warm fuzzy feeling about just doing this with only audio, but I will if y'all don't object. We've seen him. He was here the other day and we obviously saw him, so we know he exists. Y'all want to wait till we can get both audio and visual on him?
Judge, I would rather wait till we have audio and video. While I trust Mr. Statson and everything, just to cover everyone.
I agree. Joseph, can you get him to come to your office where perhaps they can provide both audio and video?
We'll work that out where he'll have video next time. When would this be recalled to?
The 12th at 2.
I'll put that on the calendar. I apologize, Your Honor, Pat.
That's okay.
Explain this to me. Why can't he get video? Most iPhones, I assume he's got an iPhone, has some sort of video capability. Why aren't we able to do that?
My understanding is the number that the phone he's dialing from doesn't have
Video
capability. And the email is for his wife's email, so he couldn't click on the link. So we had to text him a dial-in number to dial in.
Okay, do this for me if you would. Pat's already got it set for a date specific, but if you can get it all together before then, let Pat know and maybe we can work it out and get it done quicker than that, okay?
Yes, Your Honor.
Right. Thanks for your help. Y'all are dismissed. Appreciate it.
All right, thank you.
Okay, Mr. Grimes, have we heard from Mr. Marmea?
No, Your Honor, I have not.
You assume we should still wait? Actually, we're going to keep doing things today. You're welcome to wait for him. I would suggest you try to contact him by phone or computer or whatever other means you have to contact him. If you can get him here today in some capacity, we'll still do it. Otherwise, we'll reset for you. Is that okay?
Judge, that's fine. I contacted his mother, which is my only point of contact. So I'll wait here until we're done today, if that's okay with you.
Bet. Thanks for your help.
Thank you.
Okay, now we have various motions to revoke probation. First one is cause 584-901, State of Texas versus John A. Garcia, represented by Mr. George Schaffer. And are you ready to proceed, Mr. Schaffer?
I am ready to proceed, Your Honor.
Fair enough. And when we got you where you can hear us, Mr. Garcia? Mr. Garcia, can you hear us, sir?
Yes, sir.
Okay, great. Once again, this is clause 584-901, State of Texas versus John A. Garcia. This is a first motion to revoke community supervision. Garcia, I'm going to ask you to identify your signature on a couple of documents real quickly. The first one is a defendant's consent to motion to revoke hearing by video conference. Is this your signature on this document, Mr. Garcia?
Yes.
Mr. Schaefer, is this your signature on this document, sir?
It is, Your Honor.
The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document, Mr. Garcia?
Yes, sir.
Once again, is this your signature on this document?
It is, Your Honor.
Okay, I remind Ms. Gross that she is still under oath. My understanding, Mr. Shaver, this is an uncontested motion to revoke probation. Is that accurate?
It is going to be uncontested, Your Honor, with respect to all technical violations, not to any violations of condition number 1.
Fair enough. Okay, Mr. Garcia, in clause 584-901 on the first amended motion to revoke community supervision, how do you plead, sir? And Mr. Schaefer, you may plead for him if you wish.
Judge, he pleads true to any technical violation. He pleads not true to any violation that alleges a condition number 1.
Okay, let's go down the list here.
It's my understanding, Judge, that there was a failure of the class, Smart Start Mobile, failures to report. He plead true to any of those technical violations.
I've got 12 K is in Kilo, which talks about did not go to the new intervention program. I've got 12 L is in Lima, that talks about did not complete the DWI education program. I've got number 120 or 12, I guess, Oscar, I guess. Said he did not complete the DWI victim impact panel, and 20D is in Delta that talks about failed to obtain the Smart Start mobile device within 5 days. And I've got 23, which says failed to complete 8 hours of community service. Would you agree that a plea of true with an explanation to all those would be okay in this case?
That's correct, Your Honor. We'll plead true to all of those violations and only those.
Okay, Ms. Gross, would you please advise the court, the defendant, and the district attorney's office the status of Mr. Garcia's probation at this time, please?
Yes, Your Honor. Mr. Garcia has performed very poorly on probation in that after he signed his conditions, we never heard from him again. He has made no payments. He has a balance of $1,492. He did not do any of his 48 hours of community service. He never obtained the Smart Start device. He never enrolled in or completed DWI education, victim impact panel, or CAPSNIP. This is his first violation report, first MTR. The case expired December 16th of 2020. We are recommending revocation, and his original fine was $350.
And defense, would you have any statements and or requests at this time?
Judge, the only request we have is that the court give him credit for any time that he has in jail. According to your coordinator, he's got 180 days today. So whatever sentence the court imposes, we would ask the court to determine that it's a judgment satisfied.
Recommendation.
I'm sorry, I didn't hear that.
State recommendation, please.
Revocation, Judge.
Okay, does everybody agree that Mr. Garcia has 180 days credit in the Bexar County Jail that we can apply on this case? Is that correct, Vince?
Yes, Your Honor.
Yes, Your Honor.
Is that
Yes,
correct?
Your Honor.
Yes, Judge.
Is that correct, probation?
Yes.
We're getting somewhere. Okay, Mr. Garcia, in cause 584901, the court accepts your plea of true with an explanation. The conditions 12K is in kilo, 12L is in Lima, 120, 20D is in Delta, and 23. I grant the state's motion to revoke your probation. I said 6 months in the Bexar County Jail, a $350 fine plus court costs, credit for time served, time and money to run concurrent, judgment satisfied. Anything further from the state or the defense of Mr. Garcia?
No, Your Honor. With that being said, we would like to say thank you and excuse ourselves.
All good. Thank you very much. Good luck, Mr. Garcia. Thank you, Mr. Schaefer.
Thank
Yes,
you,
sir.
Judge.
Okay, next case I have is called 624186. Texas versus Sonny H. Macias, represented by Mr. Sean Simpson. Mr. Simpson,
And I don't know where they are, Your Honor.
not here right now, okay? That's okay, we have more. Next case I have is about 628236, State of Texas versus Luis Cedillo, represented by Mr. Jesse Sepulveda. Are you ready to proceed at this time, Mr. Sepulveda?
Good afternoon, Your Honor. We are ready to proceed. Yes, sir.
Okay. Mr. Cedillo and Mr. Sepulveda, about 628236. I have a couple of documents for y'all to identify your signatures on for me. The first one is entitled Defendant's Consent to Motion to Revoke Hearings by Video Conference. Mr. Cedillo, is this your signature on this document, sir? Mr. Cedillo, can you hear me? Your microphone, I think, is turned off.
Hello?
There you go.
Okay, yes, I hear you. I'm sorry.
Hey, Mr. Cedillo, do you have the ability to turn on your TV camera, so to speak, so that we can see you?
Yes, I'm trying to do that as well. Hold on. I thought
Take your time, sir. We're good. I got you. Thank you.
Can you hear me now?
Yes, sir. Gotcha. Okay. And Mr. Sepulveda, is this your signature on the defendant's consent to motion to revoke hearing by video conference document?
Yes, it is, Your Honor. Yes.
The next document I'm looking at is trial court certification of defendant's right of appeal, which is incorrectly marked as a plea bargain case, and the defendant has no right of appeal for whatever administrative reason. That's incorrect. It should be marked is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. So, Pat, if you would ensure that that is correctly marked administratively before this gets processed, that would be helpful. So, Mr. Cedillo, is this your signature on this document, sir?
Yes, it is.
Thank you. And Mr. Sepulveda, as attorney for Mr. Cedillo, is this also your signature on this document?
Yes, it is, Your Honor.
Mr. Sepulveda, as defense counsel, do you agree with the court that this document should be marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal, unquote?
Yes, I am, Your Honor.
State, same question for you. Do you agree that that is the correct paragraph to mark?
Correct, Judge.
All right, all good. Okay, this is a second amended motion to enter adjudication of guilt and revoke community supervision. Mr. Sepulveda, my understanding is this is an uncontested motion to revoke. Is that correct?
That is correct, Judge.
Okay. And Ms. Gross, I remind you that you're still under oath. Mr. Cedillo, in the second amended motion to enter adjudication of guilt and revoke community supervision in clause 628236, how do you plead, sir?
True.
Okay. Ms. Gross, would you please advise the defendant, the defense, the state, and the court the status of Mr. Cedillo's probation at this time, please?
Yes, Your Honor. And Mr. Cedillo, your camera is obstructing the view.
It's because I'm trying to listen to you because my speaker's not working.
Okay.
I'm trying to listen to you on the phone while I'm.
All right, Judge. Mr. Cedillo has performed very poorly on probation in that he reported only one time. We have not seen him since February 5th of 2020. There has been no effort to make any payments. He has a balance of $1,155. We have no proof of completion of any of the 48 hours of community service. He failed to submit to drug testing as ordered by his probation officer on his first visit. We have no proof of enrollment or completion of the stress class. This case did expire January 6th of 2021. This is his first violation report, first MTR. His criminal history includes arrests for the following offenses: fraud, use, possession, ID, info over 5 to 9, and that case was closed. Possession of marijuana, 0 to 2, terroristic threats, resisting arrest search, burglary of a vehicle, and possession of marijuana, 0 to 2 ounces. The probation department is recommending revocation. His original fine was $350.
Defense, we'd like to hear your side at this point in time and whatever your request may be.
Judge, my client acknowledges that he was not the ideal probationer. He's asking for a second shot. This was right before COVID started. Everything started locking down. He should have made more of an effort, but he was afraid to go to the probation office. He has a good job as an electrician. He's willing to comply with everything. He's willing to take his UAs and do anything the court requires him to do. So he is asking if you would please, if you're not inclined to give him the deferred, which we understand, if you would enter an adjudication of guilt and continue him on probation and give him a shot. I've discussed that he doesn't deserve another opportunity, but if you would give him one, he says that he'll complete everything. He has a 9-month-old, or actually he has a child he's expecting a child in September, his wife is, and he'd like to be around to see the birth of his son. And like I said, he's gainfully employed. He just wants to try this again.
Okay, Mr. Sepulveda, does Mr. Acevedo does Mr. Cedillo want to make a statement? Obviously, he doesn't have to.
Lewis, would you like to speak to the judge, please?
I mean, if you can, just give me another chance. I mean, that's pretty much all I can say. I mean.
Okay, thank you, sir. State recommendation?
Judge, state is along with defense, we would recommend revocation and finding him, giving him the conviction for UCW and placing him on probation for a year.
Judge, if I may interject.
Sure.
In light of information that was discussed on his first office visit, the defendant did admit to being a chronic marijuana smoker. If the court would so be inclined to place him back on regular probation, the probation department would request that, number one, we add a drug offender education class to address the chronic marijuana use, and that also he be placed on zero tolerance probation. He was, let's just say, less than nice when he visited with his probation officer. There were a lot of 4-letter words and derogatory comments made in regards to being on probation, and that it was a lot of BS. And F this place. And if that's going to continue, then he is not going to be a good candidate for probation. And we would rather just cut to the chase and let him do his time at this time in the event that that behavior continues.
Your Honor, if I may, I think Mr. Cedillo regrets that whole exchange. He's told me so. He would like an opportunity to prove himself. He doesn't want to be incarcerated for this. I don't think it would do anyone any good. But he is remorseful for the way he acted. Is that right, Lewis?
Yes, I am.
Anything further, State?
No, Judge.
Judge, one more thing. If you are inclined to allow him to do regular probation in lieu of the deferred, he does work as an electrician. Like I said, he makes good money, but he does have to work throughout the state. So if you would allow him to travel to, if his work requires him to do so.
Mr. Cedillo, in clause 628236, the court accepts your plea of truth. The second amended motion to enter adjudication of guilt and revoke community supervision. I grant the state's second amended motion to enter adjudication of guilt and revoke community supervision. I find you guilty of the offense of unlawfully carrying a weapon, to wit, a handgun. I sentence you to 1 year in the Bexar County Jail, assess a $4,000 fine plus court costs, credit for time served, time and money to run concurrent. You had to report to the Bexar County Jail at 9:00 a.m. on Monday, May 10th, 2021, to give you time to get your affairs in order. Anything further from the state of the defense on Mr. Cedillo?
Judge, would you allow work release?
I don't think there is work release right now, and you're welcome to check on this and get back to me. Jess, number one, if he's working out of town, that's not going to work. Number two, the last time I talked to anybody at the jail about work release during the plague, so to speak, they indicated that people stayed at home and worked from home, and that was supposed to be their work release, but that's not going to work for me. So you're welcome to look at that. If there was a way where you could sleep in the jail and go work during the day, I'll be happy to consider that, but I'm not sure that exists right now.
Yes, sir. You wouldn't grant the probation then?
I can't get him to show up for a year for probation. I have a very difficult problem thinking he's going to change his ways and show up again. It's just the way it is. So I apologize, Mr. Cedillo, but I don't have a whole lot of choices in this. It's kind of a textbook solution.
Yes,
all right. Good luck, Mr. Cedillo. Thank you, Mrs. Sepulveda.
Thank you.
Your Honor, Mr. Macias is back on. I found him.
Oh, great. Okay, back on the record on 624-186, State of Texas versus Sonny Macias. Macias. Is Mr. Macias online with us now?
Yes, Your Honor. He was in a breakout room.
And Mr. Goins, do y'all need to have a chat in a chat room before we go into this, or are y'all ready?
No, Your Honor, we're all ready.
All right. Mr. Macias, this is called 624-186, State of Texas versus Sonny H. Macias. I have a document. Actually, I have one document. Two documents for you to identify your signature on for me. The first one is entitled Defendant's Consent to Motion to Revoke Hearings by Video Conference. On this document, sir.
Yes, sir.
Thank you. And Mr. Simpson, as attorney for Mr. Macias, is this your signature on this document?
Yes, it is, Your Honor.
The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal.
Your Honor, breaking up. We can't hear you.
Yes, Judge, none of that.
Yeah, it's because Mr. Macias needs to mute his microphone unless he's being spoken
Let me
to.
try.
We're picking up the jail. There we go.
Okay. Try it now.
Okay, let me try it again. Mr. Macias and Mr. Simpson, the document I'm looking at now is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction, unquote. Mr. Macias, is this your signature on this document, sir?
Yes, sir.
Thank you, sir. And Mr. Simpson, as attorney for Mr. Macias, is this your signature on this document, sir?
Yes, Judge, it is.
Thank you. This is a first amended motion to revoke community supervision. It is my understanding this is going to be an uncontested motion to revoke. Is that correct, Mr. Simpson?
That is correct, Judge.
Okay. Ms. Gross, I remind you, you're still under oath. On the first amended motion to revoke community supervision, how does Mr. Macias plead?
He pleads true, Your Honor.
Okay, Ms. Gross, would you please advise the court and the parties of the status of Mr. Macias' probation at this time?
Yes, Your Honor. Mr. Macias has performed poorly on probation in that he never showed up to sign his conditions. There have been no payments made. He has a balance of $1,100. He is delinquent $320. He has done 0 of 36 hours of community service. He never obtained a Smart Start mobile device. We have no proof of enrollment of victim impact panel, DWI intervention or CAT-SNP. This is his first violation report, first MTR. He has a criminal history arrest record of burglary of a vehicle, unlawful carrying of a weapon, possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200, possession of a controlled substance, penalty group 1, less than 1 gram, DWI open container, and a fail to stop and give info. He was not assessed a fine on this case, and the probation department is recommending revocation.
And defense, would you please advise the court and the parties of your request and anything else you'd like to tell us at this time?
Yes, Judge. Mr. Macias has been in custody for, I believe, 180 days on some unrelated matters. We're asking that the court revoke his probation, give him credit for the 180 days, and JSAT him. I think all parties are in agreement to that. He's not going to be leaving the Bexar County facility because of the other pending charges.
Let me ask this. He has a pending open case in cause 651036. What kind of case is that?
Judge, that's a debating and it's tied up with the felonies. So the prosecutors want to hold on to that for right now.
I got it. Okay. My records reflect that Mr. Macias has accrued 188 days in the Bexar County Jail on this case and 167 days on the new case. Does that sound right, defense?
That is correct, Judge.
And state, do you agree with that? State, do you agree with that? That's the number of days that he has already spent in jail. Nick, your microphone is still on off.
Sorry, Judge, I was frozen. What was the question?
Oh, no. My question is, my records reflect that Mr. Macias has accrued 188 days in the Bexar County Jail or some jail on this particular case and 167 days on the new case. And
correct, Judge.
Do you agree with that? Correct?
Correct, Judge.
So if he were to be revoked today, I give him the sentence, I think the maximum sentence on this case is 6 months or 180 days. You would agree that I can apply those amounts of time in jail to that sentence. Is that correct?
Yes, Judge.
Okay. And defense, you agree with that?
Yes, Judge.
And Ms. Gross, what was the original fine amount on this? Do you recall?
Judge, he was not assessed a fine in this case.
$0 fine. Okay, I got it. Mr. Macias, in cause 624-186, the court accepts your plea of true. Do all conditions on the motion, the first amended motion to revoke community supervision. I grant the state's motion to revoke your community supervision. I sentence you to 180 days in the Bexar County Jail, assess a $0 fine plus court cost, credit for time served, time and money to run concurrent, judgment satisfied. Anything further from the state of the defense on Mr. Macias in clause 624-186?
No, Judge.
Nothing from the defense, Your Honor.
Mr. Macias, thank you, Mr. Simpson. Thank you, Ms. Grove. I think we're.
Thank you, Judge. May we be excused? Thank you, Pat.
Thank you.
Okay, so at some future point, we've got Mr. Martinez still to go. We did Mr.
Yes.
Martinez.
We need the interpreter.
Yeah, we got Mr. Macias. We got Mr. Cedillo. So all we have left is Miss Aleman. Is that correct?
Yes, Your Honor. And we need the, there we go. Okay, so now you need to hit it, Your Honor. Thank you.
Sí, sí, le escucho.
Okay, we got Miss Pollock and we have Miss Aleman with us there. Oh, I got it. Mr. Aleman, excuse me. Okay, this is cause 389841, State of Texas versus Blanca Aleman. And initially, let's see, this is a Motion to set aside information for failure to afford constitutional right to speedy trial. Ms. Pollack, would you please clarify for the court and the state what exactly your motion is requesting?
Judge, we're asking this case, it's a trademark counterfeiting Class B misdemeanor, be dismissed under the Sixth Amendment to the United States Constitution as applied to the states by the 14th Amendment.
Okay. And so I have a couple of documents, or I have one document, I guess, for y'all to identify your signatures on. So I'm looking at a document entitled Defendant's Consent to Hearing by Video Conference, which reports to have your signature and your attorney's signature on it. Is this your signature on this document?
Sí, yo firmé.
And Ms. Pollack, as attorney for Ms. Alaman, is this your signature on this document?
Yes, Your Honor.
Thank you. Okay, original case number is 389841. And state, if you would, and Ms. Pollack, pay close attention so you can verify or refute their document. I need to know the specific dates that are involved in this case, like the date of arrest, the date the information was filed, the date my understanding is it was filed at large from our last short hearing.
Good.
So the date that Solomon was actually arrested, and any other pertinent dates that either side feels are relevant to what we need to do today. So, State, have you got any of those in front of you at this time?
Yes, Judge, I do. So the offense date, and correct me if I'm wrong, Ms. Pollack, on any of these, because sometimes it gets a little confusing. The offense date I have is 7/10/2011. The case was formally filed at large and the warrant was issued on 4/13/2012. The warrant was successfully executed and she was arrested on 9/30/2020. And I'm not sure if you need any other dates.
Ms. Pollack, do you agree with those dates?
Well, I believe she was arrested on July 17th of 2020 was the information I'd received from the clerks of your court.
Okay, so your records reflect that Solomon was arrested on July 17th, did you say?
Yes, Your Honor.
And what year, 20?
2020.
2020. And State, you have information that said it was in September. Oh, I'm sorry. What date did you have for the arrest date, State?
9/30/2020. But if you give me a second, Judge, I can.
Your Honor, if I may.
Go ahead, Pat.
Okay, I'm looking at my timeline, the chrono. She was arrested 7/17/2020. We received on September 30th the out-of-county bond.
Okay.
I mean, I prefer the court's date on the arrest, but.
But that's what the timeline shows. She was booked on that date, but it was out of county in Wilson County, I believe.
And I guess this motion was filed on or about March 10th, 2021. Do we agree on that?
I'm sorry, you broke up, Judge.
Are there any other dates that are pertinent to our analyzing this?
Not that I'm aware of, Judge.
Okay.
I don't believe so.
Since I don't know nothing about this case, I'm gonna let y'all advise me. My understanding is that the offense date was allegedly July 10th, 2011. The information was filed April 13th on or about 2012. And the defendant had no knowledge that this had been done, apparently. And so she was at large and this was filed at large. And so her first notice that this was going on was she was arrested on July 17th, 2020. Would you agree with that, Ms. Pollack?
Yes, Your Honor.
And State, obviously you don't know the mind of the defendant, but those are the dates that we've established. Do you agree with those?
Those are the dates, yes, Judge.
Okay, Ms. Pollack, go ahead and tell me why the speedy trial situation under Barker v. Wingo is applicable to this case. Let me just state for the record, my understanding, there are 4 factors that were derived from Barker v. Wingo case. 1, the length of the delay. 2, the reasons for the delay. 3, the assertion of the right. and 4, prejudice to the defendant resulting from the delay. State, do you agree that's the law?
That is the law, Judge.
Defense, do you agree that's the law?
Yes, Your Honor.
All right. Ms. Pollock, go ahead, and if you would, plug in facts of your case to my 4 factors and explain to me why they're applicable to this case, if you would.
Well, Your Honor, we would ask that you take judicial notice of all those dates, and we would assert that this case has taken over 8 years to bring to court. We would assert that this has certainly met the threshold from turning into an ordinary delay into an extraordinary delay. And that we would like to present evidence on the 4 factors of Barker versus Winger. We would call some witnesses.
1 second. Miss Pollock, sorry, Miss Alaman, can you mute your microphone? Because I think y'all are in the same building, so it's picking up feedback. Thank you.
Okay, and Ms. Pollock, did you say you wanted to call witnesses, correct?
Yes, Your Honor.
Go ahead, call your first witness.
I would call Karina Pantoja.
And is she online with us today?
She is in the room with Miss Alaman.
Okay.
Can you turn the camera?
Hello,
Good afternoon, Mom. For the record, would you please state your name?
Karina Pantoja.
Let me ask you to please raise your right hand. Do you swear that, would you raise your right hand, please, ma'am? Thank you. Do you swear the testimony you are about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you very much. Ms. Pollock, your witness.
May I call you Karina?
Yes, ma'am.
How are you related to Blanca Alaman?
My mother.
Okay. And what do you do for a living?
I'm a medical assistant at Total Men's Health.
And where do you reside?
At 166 Solar Drive, Lot 2, near Texas.
Did she break out for you, Judge? How long have you resided at this address?
About 23 years.
And do you know who owns this home?
Blanca, my mother.
And when did she purchase this home?
In 1998.
Now, I have shown you a body cam video, apparently from an investigator from the date of this alleged offense. Did you see yourself in that video?
I sure did.
And did you hear your voice in that video?
Yes, ma'am, absolutely.
Now, did that playing of that video, what are your recollections from the day of that event?
Honestly, I don't remember. It's been years.
Did playing of that video, did it instill any, did it bring back any memories of that day? So you were a witness apparently that day, but you've not been able to provide me with any information. Is that correct?
Honestly, no.
Now, there was another witness to that event that was in that video. Is that correct?
Yes, ma'am.
And do you know the name of that witness?
Cirilo Suarez.
And how is he related to you or your mom?
Ex-boyfriend of my mom.
And you say ex.
An ex.
They were together on this date of the alleged incident, right?
Correct.
How long after did they break up?
I want to say about a year or so.
Do you have any idea where this witness is located?
No, ma'am.
You have not been able to provide me with any phone numbers or addresses for this witness?
No.
To your knowledge, well, first of all, were you arrested on this date?
I was not.
Do you know if your mom was arrested on this date?
No, she was not.
Was she issued any kind of notice to appear in court?
No, she did not.
Has your mom, besides being arrested last year on this charge, has she ever been arrested before?
No. No, ma'am.
Now, do you know if your mom has ever gone to DPS to have her license renewed?
Yes, ma'am.
Now, how do you know that?
I always go with her
Why do you go with her?
to assist her and interpret her. And
So how many times during this period of time from this alleged offense date to present, how many times have you taken her to DPS?
twice, if
I'm
I'm
sorry?
not mistaken. Twice, if I'm not mistaken.
And was she issued a driver's license at those times?
Yeah.
Did anyone ever tell her that she had a warrant outstanding?
Yeah.
So you have lived at, what's your address right now again? I'm sorry.
166 Dollar Drive, New Braunfels, Texas.
Now, apparently, based on the discovery packet that I received from the state, they had confiscated your license, or they had taken photographs of your license, your mom's license, and what is your mom's boyfriend's name?
At the time,
Yes.
Cirilo Suarez.
And I've shown you those documents, correct?
Correct.
And what is the address that is listed on those driver's licenses?
166 Dollar Drive.
For you and your mom, is that correct?
Correct.
Now, I'm having a hard time with his name, but the ex-boyfriend,
Yes, ma'am.
his documentation was from Mexico, is that correct?
Correct.
Now, how long has your mom lived at that address, to your knowledge?
Since 1983.
Do you know if any law enforcement ever came to her home to notify her of these charges?
Not that we're aware of. No, ma'am.
You never found any cards from any law enforcement officer on the door or in the mailbox?
No, ma'am.
I believe that's all I have for this witness, Judge.
Hey, do you have any questions for this witness?
Yes, Judge. Hello, ma'am. How are you doing?
Hi. Hello.
So I just have a few questions for you. So, do you know where the charges were brought? What county the charges were brought in?
What county?
Where the offense
county,
took
no, but
place?
she was in Lavernia.
She was in Lavernia?
Uh-huh.
Okay. And the address that you stated that, and you said your mom and you have lived at that address since 1998, is that what you said?
1998.
1998. And
Yes.
and that is in New Braunfels, Texas, correct?
Correct. Yes, sir.
Which is located in Comal County, correct?
Yes, sir. Correct.
Which is not the county where the offense took place or where we're having this proceeding.
Correct.
Okay.
Correct. Mhm.
Okay. Additionally, Ms. Pollock asked you if you had any recollection of the video when you watched it, and you stated that you recognized your voice and you recognized the image of yourself. Is that correct?
Mhm.
And additionally, that when asked further about what happened that day, you couldn't remember anything.
Honestly, no.
Even after watching the video, it didn't jog your memory at all.
Mhm.
Okay. Do you know any reason why maybe you would just have no idea?
I'm sorry.
Do you have any reason why you would just have no recollection of that date specifically?
Because it's been many years ago and I was at the time 15, 16.
Okay, that's fair. So you also stated during that you've taken your mother twice, you said, to DPS to get her license renewed. Is that correct?
Yes, sir. Correct.
And you remember specifically doing that?
I remember, yes, I always come with her to appointments when I can.
So just to clarify, you remember specifically taking your mother to DPS twice to renew her license, however, have no recollection of what happened the date of the offense, even though you were shown a video of what happened.
Honestly, yes. Honestly, the day of the incident, I do not remember.
Okay.
As much as I want to, I just don't remember.
Okay. And the two times you took your mother to DPS to get her license renewed, do you remember when those might have taken place in the period of time we've been talking about?
Okay, so the first time would have been when she got a divorce, so she had to renew everything, and that would have been a little bit after 2015 or 15, around there.
Mhm.
And then recently in July of 2020, at the time I wasn't working because of the whole pandemic, so I went with her, and I remember the time, and I drove her there.
Okay. And just to be clear, you weren't asked to like remember these DPS visits and things like that. You just, off the top of your head, when asked by Ms. Pollock, she told you remembered taking your mother to DPS off the top.
Correct.
Okay. No further
Correct,
questions.
because
Ms. Pollock, any further?
No, I don't believe I do.
May this witness be excused?
I'm sorry.
May this witness be excused?
She can't, according to me. I don't know about Mr. Maru.
No further questions, Judge.
All right, so this witness may be excused. Is that correct, Ms. Pollock? I mean, she may stay in the same room with her mom if she wants to. The state's not going to object. I don't think to that. Under the circumstance. All right, call your next witness. Thank you very much for your testimony, ma'am.
thank you so much. Thank you.
Pollock, call your next witness, please.
I would call Miss Alamán.
Sí, la escucho.
Okay. Good afternoon, Ms. Aleman. We're going to use an interpreter, so
Buenas
people
tardes.
who don't speak Spanish will understand what you're saying. And Ms. Pollock, Ms. Aleman, would you please raise your right hand? Do you swear the testimony you're about to give will be the truth, the whole truth,
La verdad.
and nothing but the truth, so help you
Y
God?
la verdad. Lo juro ante Dios, sí.
Thank you, ma'am. Ms. Pollock, you're
Gracias. Sí, cómo no.
Would you state your name for the record?
Blanca Alemán González,
And how old are you, Ms. Gonzalez?
49 años.
And where do you reside?
$166 Road, New Braunfels, Texas.
And how long have you resided there?
Desde el 98 hasta ahorita.
I'm sorry, I'm not hearing the,
Yeah, no, I'm only here. Oh, I'm hearing like both, and it's kind of like laying over each other. Like I can hear Ms. Alamán speaking in Spanish, and then I can hear the interpreter speaking in English at the same time.
I can't hear the English response.
Okay.
I did that.
You hit it to English?
Okay, I did that.
Does that help? You don't know because you're not talking.
Okay. I hit my.
Sí, sí la escucho, sí la escucho. Sí.
Okay, now I got it. Now I'm better.
Thank you.
All right. May I
Okay, está bien,
proceed?
sí.
So I'm sorry, how long have you resided at this address?
24 años, más parece que sí, desde el 98 hasta ahorita.
And do you own this home?
Sí, señora, soy dueña de la casa.
And have you continuously resided at this residence since you purchased the home?
Sí, nunca me he movido de ahí. Toda mi vida, desde que estoy aquí, ha sido en mi casa. No me he movido a ningún otro lado. Ok.
Are you a U.S. citizen?
Residente.
So you have a green card to work here, is that correct?
Sí,
And do you work?
sí trabajo.
Where do you work?
BMC Select en New Braunfels, Texas.
And how long have you worked at this business?
15 años.
Now, you know now that you have charges pending out of Bexar County, Texas. Is that correct?
Sí lo sé.
When was the first time you learned of these charges?
Cuando me arrestaron en la Bernia, fue el 2020.
Why were you arrested in Lavernia?
Porque no hice un alto bien y me arrestaron. Me prendieron las luces y me arrestaron.
So you were stopped for a traffic violation, is that correct?
No fue exactamente, nomás que no hice muy bien el stop y fue cuando me arrestaron.
Still traffic violation.
And the officers ran your name on a computer, I guess, and found a warrant for your arrest out of Bexar County. Is that true?
Así es.
And that is the first time you learned that you had these charges out of Bexar County. Is that right?
Sí, así es.
Now, have you ever been, besides being arrested in late 2020, have you ever been arrested before?
Ninguna vez. Fue la primera vez.
Now, do you remember any police officers, whether it be Comal Sheriff's deputies or Bexar County deputies, coming to your home and informing you that you had these charges?
No, nunca han ido a mi casa, nunca se presentaron para nada.
Has anybody ever called you and informed you that you had these charges?
No.
So nobody from the Bexar County District Attorney's Office ever called you and informed you, you have a court date on such and such, or come in, let us execute this warrant?
No, señor.
Now, this alleged offense apparently occurred at Mission Flea Market. Is that right?
Sí, cierto.
When was the last time you were at Mission Flea Market?
No recuerdo la fecha exacta en que dejé de vender, no recuerdo.
Was it shortly after this alleged incident? Has it been maybe?
Sí, fue poco después.
So have you lost contact with the people from Mission Flea Market?
Así es.
Do you have any specific recollection of these events that occurred on July 10th of 2011?
Yo me acuerdo cuando fueron a mi puesto y me dijeron que eso era ilegal, que no debería de venderlo. Y yo le dije, está bien. Y se llevaron las bolsas y me dijeron, te va a llegar algo por correo en tu casa para que te presentes a corte, y jamás me llegó nada.
Now, I showed you that same video that I was talking to your daughter about. The body cam video of some investigator or detective. Is that right?
Sí, sí me lo enseñó, sí.
And did you see your boyfriend, then boyfriend, Cirilo Suarez on that video?
Sí, ahí estaba.
Have you been able to provide me, when did you and Mr. Suarez part ways?
Sí. Después de que pasó un año después. Más o menos un año después.
Do you know where this witness can possibly be located?
No, perdí contacto absoluto. No sé nada.
He was from Mexico, is that correct?
Sí, sí, él era de mí. Sí.
And you have no information to provide me as far as where I can contact this witness, telephone number, address, etc.
Perdí contacto absoluto de él, no sé nada, no sé nada.
Now, between the date of this alleged offense and present, you've been divorced, is that correct?
Yo me divorcié en 2015 en agosto.
And where did that divorce take place?
En New Braunfels.
Did you have to appear at the New Braunfels courthouse?
Sí, sí me presenté.
Did anyone there ever inform you that you had a warrant out of Bexar County?
No, no se me informó nada.
Was your name changed during this divorce?
Sí.
And did you subsequently renew your driver's license, changing the name on your driver's license to your maiden name?
Sí, así fue.
But your address was still the same. Is
Es
that
la
right?
misma, exactamente la misma.
Did anybody at DPS ever inform you that there was a warrant out for your arrest?
No, para nada, se me informó nada.
So sometime around 2015, 2016, you remember going to DPS and renewing your driver's license, right?
Exactamente.
When was
Exactamente.
when was the last time you went to DPS to renew your driver's license?
Fue en el julio de 2020 la última vez.
That was just about a few days or so before you were arrested during that traffic stop. Is that right?
Sí,
And did anybody at that point from DPS tell you you had an outstanding warrant?
no, no se me comunicó nada.
Okay, we've discussed this case a few times. Is that right?
Sí,
And have you been able to provide me names of any witnesses that I could contact in regards to this case?
no, porque no los hay.
Besides your daughter?
Aparte de mi hija, ajá, aparte de ella no hay más.
I believe that's all I have, Your Honor. I'll pass the witness.
Hello, ma'am. How are you doing?
Buenas tardes.
So I just have a few questions. So Ms. Pollock brought up how you didn't receive any phone calls or no one came to your door, knocking on the door, or anything like that to inform you of this. As you can see, we have an interpreter here now. So I'm just curious, your vocabulary when it comes to English, is it broad? Do you know a little bit, or is it just you don't know any?
No, entiendo lo básico nada más, unas que otras cosas lo puedo hablar, pero no al 100%.
So it's possible that if a BCSO officer, a sheriff did call attempting to contact you about the warrant, that either you hung up or there was a language barrier and you didn't understand what was going on.
No puede haber esa posibilidad porque casi la mayoría a mí de que me hablan son en inglés. La mayoría de gente que me habla es en español, perdón.
So when the bears, so, okay. Oh, that's interesting. Another question. So going back to the date of the offense, when this whole thing allegedly happened, you said that a man came in and took the money out of your purse, correct? And then took the bags as well and informed you that you would be getting something in the mail, correct?
Sí, informo, no me quitó el dinero de las bolsas, se llevó las bolsas, el dinero nunca me lo quitó.
Okay. Judge, I don't know if I introduce an exhibit or share screen or how you want to do it, Ms. Pollock, and I would like to show it to you first, but it's the offense report.
How many pages is it?
It's a couple pages, Judge, but it's just the main point in the offense report.
Text it to me. Would that be possible?
I don't think I can text it, Judge. I can email.
Well, if you take a picture with your cell phone, then
yes,
I can,
Judge.
for purposes of what we're doing, I think that would work okay.
I can do that.
Your Honor, I don't understand the relevance of the police report. I would object to it. We're not here to try the case.
No, we're not trying. We're not trying the case. It's just she made a statement and it's counter to what the offense report states.
Well, let me cut to the chase on this deal. What are you trying to? And obviously, I know nothing about this case or the original arrest. Correct me if I'm wrong. Apparently, the defendant was arrested for selling purses at a flea market, and these purses were allegedly not original fashion purses. They had fake names on them or something. Is that what the allegation was?
Correct, Judge.
Okay. And so what are you trying to point out by me looking at the police report, Mr. Maru?
All I'm trying to point out is that the police report does state that the money was recovered from the purse. So maybe her recollection of events may not be as she has been stating and has been on test or has been testifying during this line of questioning.
Judge,
But anything's possible. So,
I'm sorry.
Ms. Pollock, I'm going to sustain your objection. I don't need the police report, but your point is noted for the record and for appellate purposes, Mr. Maru. But I'm going to point out that that was an awful long time ago, and everybody's recollection from that long ago is probably going to be a problem. Okay, go ahead and proceed, Mr. Maru.
So as I was saying, ma'am, so you recall they took the purses and they told you that you shouldn't be selling them and that they would be giving you something in the mail, correct?
Así es.
But you do not recall them taking the money back.
No recuerdo que me hayan dado el dinero de regreso, no me acuerdo que se lo llevaron, más me acuerdo que se llevaron las bolsas.
Okay. And then one final question. The home that you've been living in since 1998 is in New Braunfels, Texas, which is located in Comal County, correct?
Cierto.
And when you would go get your license renewed, would you do that in Comal County?
Exactamente.
Okay. No further questions, Judge.
Ms. Pollock, anything further for this witness?
Just one question. You were arrested in what city?
En Bernia, en la Bernia, como a las 3:10 de la mañana.
For the traffic violation in 2020, is that correct? I mean,
exactamente, sí.
You were stopped. Do you know what county that's in? Do you know what county Livonia is in?
No sé porque yo ahí me cité con mi novio y yo me paré temprano para irme a trabajar, pero no, yo no sé de qué condado es la Bernia.
Ms. Paul, oh, sorry, go ahead.
I'm sorry, were you going to say something, Mr. Marie?
Yes, but I didn't mean to cut you off. I was going to say, if you want Judge Christian to take judicial notice of what county Livonia is in, I will not object to that.
I don't even know what county. Do you know what county that's in, Mr. Marie?
I do know what county that's in. That's located in Wilson County.
Judge, if you could take judicial notice that it's in Wilson County.
Well done. Thank you.
All right. Certainly Wilson County had information in their system that there was a warrant out of Bexar County. Is that right? That's what they arrested you on.
No sabré decirles si sabían que tenía arresto o no sabía. Yo sé que nada más me llevaron a Flores Bio y de ahí ya.
And you bonded out of Floresville on the Bexar County warrant. Is
Sí,
that
así
right?
es.
That's all I have, Your
Así
Honor.
es.
Anything further, Mr. Maru?
No, Judge.
All right. I assume this witness may be excused. Obviously, he's not going anywhere.
Yes,
All
Your Honor.
Thank you very much for your testimony, ma'am. Ms. Pollock, call your next witness.
I would rest, Your Honor.
Okay.
Sí, está bien.
Let me ask a few questions, and then I'm going to let y'all do final argument type stuff. Mr. Maru, do you have any idea why the police didn't arrest the defendant right there at the scene instead of file it at large? Is there any reason for that?
Judge, it's not stated in the report. It just says that it was passed on to a detective, which I am in contact with the detective on this case. As crazy as it may seem, he is still with the department, as well as all the agents who played undercover and were witnesses to what was going on. They're also still available.
Is it an SAPD case or a Bexar County Sheriff's case, or what is it?
1 second, Judge. SAPD case, Judge. This is SAPD, Judge.
And did you check and see if they still have these handbags and evidence? I guess is what they would have to have done.
When I spoke to the detective handling the case, and when I spoke to let me see, I can look on the offense report, his main designation. But what he does is he works for these huge trademark Louis Vuitton, Burberry. He works for all these, and he stated that he did have all of the evidence still, and still was prepared to testify if need be.
So it's the state's position that you're still wanting to go forward on the prosecution in this case, is that correct?
Correct, Judge. We have an adamant victim.
Okay. Who's the victim? I thought the victim would be like the state of Texas. Who's the victim?
The victim is actually this company that represents Louis Vuitton. One second, Judge.
Oh, I see. Okay, I got you. I understand. Okay. Ms. Pollock, confirm for me. I think I got through your client's testimony that the first time she was made aware that charges had been filed against her was the date she was arrested for, after the traffic stop. Does that sound right?
Yes, Your Honor. July 17th, 2020.
Gotcha. Okay. Does anybody else want to put on any state? Do you have any evidence to put on that you wish to? I just want to go step by step through these 4 different prongs, and then I'll rule.
That's what I was going to do, Judge. I was just going to provide evidence for the final prong, which is the prejudice. What Barker states is the main element in that is if there's an impaired defense. As you see, we have her daughter there. Whether or not she can recollect anything or recall anything is not really an issue. It's whether or not she is able to testify, which she is. As we saw today, she was able to do that. We also have the detectives and the witness who conducted the sting operation and the victim, which I did just have that pulled up. They are all willing to testify. So as far as the state is concerned, a defense has not been impaired. Addressing the boyfriend, which defense states they would like to call, if they could provide me with a name, and then I have a phone number in the offense report and an address, I could have my investigator look into his whereabouts and see if we can bring him in to try to help the defense gather some of their witnesses if they think that this is what the motion is hinging on. That's it, Judge.
Okay. Ms. Pollock, let me ask you a couple of questions, then you can go point by point on these different 4 prongs. What witnesses has the defense lost over that long period of time that you are concerned about? Apparently, is this the defendant's current boyfriend or ex-boyfriend that you're missing?
We are missing that witness. We are missing the memory of her daughter. We are missing my client's memory. 10 years has passed. Memories fade. We have lost any contact with any possible witnesses from the flea market. She has not been back to that flea market for, I believe her testimony was shortly after this alleged incident, which would be over 9 years. We could have possibly gotten witnesses from the flea market. They have to prove that she had knowledge that or should have known that those purses were counterfeit. These witnesses go to her state of mind, whether or not she had knowledge. They have to prove that she intentionally possessed or sold these items, knowing they were counterfeit. The witnesses, we possibly could have found witnesses who could have gone to that element of the state's case. So I would say we've lost a whole lot in 10 years, including faded memories.
Here's my question, once again. Is the boyfriend an ex-boyfriend or a current boyfriend that you're missing as a witness in this case?
Her testimony was that they broke up about a year after this alleged incident. We have no idea where he is. She thinks he's in Mexico.
And if you had him, what would he be able to testify about in this case?
He was a witness there during, he's seen on the body cam video. I would certainly like to be able to talk to him on various elements of this offense.
Okay, so your position is, obviously he was present at the scene when the police had a conversation with, I guess, and seized these purses from your client. Is that accurate?
He was present at the scene. They confiscated or took a picture of his Mexican ID card.
Okay. And what other witnesses are you missing? I don't want to hear about ones that may have been there and you don't have, obviously the time, you don't know who else was at the flea market. What specific individuals do you know of that you would call as a witness at this trial but you can't, because of the length of time, you can't get them.
Judge, that's the whole point. Because of the length of time, I cannot be specific because 10 years have passed and I could have gone out to that flea market. I could have talked to people around this booth. I could have gained information regarding Miss Alamon's state of mind at that time, whether or not there was knowledge of counterfeit goods.
Okay, let's go little steps for little feet, starting with the length of the delay. My understanding is that Parker v. Wingo, cited as 407 U.S. 514, 534, 1972 decision, basically talks about the length of delay starts either at the time of the arrest, which in this case would have been 7/17/20, or the formal preferring of charges, which in this case would have been when the information was filed 4/13/12. It's my understanding that the defense position is that the court should assume that the time starts running 4/13/12 and not when she was arrested on 7/17/20. Is that accurate?
Correct, Your Honor.
State, I assume the state's position is the time should start running at the date of the arrest, 7/17/20, and not the date of the information being filed, 4/13/12, because the defendant had no knowledge that charges were being filed and therefore suffered no prejudice. If she didn't know they were there, why is it bothering her, kind of thing? Is that where your position is?
Judge, while I do agree with the prejudice factor, Barker v. Wingo does state that for an at-large case, you start counting from the date it was filed. Prejudice aside, that is when we start counting.
All right. And aside from not being able to get witnesses and whatnot, did the defendant, and this is a question for Ms. Pollack, I'm sorry, did the defendant suffer any mental anguish or anything else before the time frame she was arrested and made aware of these charges?
No, Judge, we're not alleging that element. We're alleging just prejudice to the defense because of the length of time.
Okay, I got it. Anybody want to make any final comments here? Now's your chance. We'll start with the defense. Ms. Pollack, you have anything else you want to add?
Well, arguing the four Barker versus Wingo cases, the length of the delay in this case, presumed prejudice in Texas happens after 8 months from the case law. It tells us 8 months is the presumed prejudice. In this case, we have over an 8-year delay in bringing Class B misdemeanor charges against my client. 99 months has passed. I mean, it's extraordinary. The state has presented no reason for this delay. He states somehow because she lived in Comal County as opposed to Bexar County, they still have a duty, and this happens so often in these at-large cases. They will file their information or indictment and think that's all they have to do. No, they have a burden to bring a defendant to trial. It is their burden. It is their case. It shows you that they were no more interested in trying this case. They waited over 8 years. You know, they have no interest in bringing this case, but suddenly now they do because they found her through a traffic stop. She's resided at the same residence. She's renewed her driver's license 2 times. There have been no attempts to execute on this warrant until she was stopped for the traffic violation. The state has brought forth no evidence to show what efforts they have made. So this factor works heavily against them on the second prong of the Barker versus Wingo reason for the delay. And regarding the timely assertion of this right, Ms. Alamon was brought in April. I was appointed sometime in October. There was some delay in getting evidence downloaded. It took me a while to research this case, talk to my client. We were having language difficulties. The case was, she was our first setting, and I was appointed October 7th of 2020. The court reset this case to December 3rd. It was again reset by the court February 18th. I filed my motion to dismiss this case on March 10th. And that delay was caused by, I say again, there was some delay in downloading the evidence. I had problems communicating with my client. I was researching this case. As soon as I determined that there was an issue of over 8 year delay in this case, I filed my motion. You know, my client, she had no knowledge of this case. She can't bring herself in any sooner than we did. She had no knowledge. Again, it's a state's burden to bring a defendant into court. It's their charges. I would assert that this factor works against the state and in our favor. So now we've got the 3 factors working in our favor. The prejudice because of the length of delay, I would say because it was such an extraordinary length of delay in this case that the court, based on the case law as it is now, and I would cite the court to Doggett and especially Gonzalez out of the state of Texas, written by Judge Hervey. That was a serious felony offense, injury to a child with serious bodily injuries. There was an over 6 year delay in that case, and it sets out very similar to our case. It was an at-large case, and in that case, they said that because of that 6 year delay, it was so prejudicial that the burden shifts to the state to show that there is not prejudice. And we understand that that's a very almost impossible task, but the court has told us that is where we are in these extraordinary delays. And they were basing their finding and holding on Doggett out of the US Supreme Court. That was an 8.5 year delay, which is very similar to the delay we have in our case. And again, that was a more serious offense, felony offense. It is almost impossible for the defense in these cases where the length is so long to show exactly where the prejudice lies. But the courts are telling us the burden should not be on the defense. It's a state who delayed the case. They should rebut the prejudicial impact of the delay. And I would assert that the state has nowhere at all shown that they have rebutted our presumption that we are prejudiced by this delay. You've heard memories of these witnesses, they cannot remember because of the almost 10 year delay from the date of the offense. So we would ask that this case be dismissed with prejudice. We have met all prongs of the Barker factors. We would ask the court to read the Doggett case out of the US Supreme Court and read the Gonzalez case, which was handed down in 2014. And I would continue to rely on the case law that I've cited in my trial brief. I filed that along with my motion. The states had copies of that along with the court has had copies since I filed that in March. They have not responded with any other case law. We would ask that that motion and trial brief be included in the record in this case, and we would ask for dismissal with prejudice.
Thank you. State.
I'm gonna make this brief. So we cannot dispute the length of delay. Time is time. It was 8 years, but that is why the court proceeded to lay out 3 more factors in Barker and not just call it right there. The cause of the delay, one of the things in Barker they say to look to is if the defendant contributed in any way. From the testimony you heard today, She said she was supposed to be getting something in the mail. As far as we're concerned, I mean, she could have made an attempt. While she does not have a duty to make an attempt, it could have been done. And if they're claiming that they're prejudiced from witnesses and that was their main concern, well, then they could have done something about that. Additionally, as far as the state's concerned, the defendant was a fugitive for over 8 years. And once that at-large case is filed, she's a fugitive. So, I mean, as far as the state's concerned, the defendant was a fugitive for 8 years. Going towards the assertion of right, we do not dispute that once she found out she had these charges against her, that Ms. Pollock did file this motion and did assert their right to a trial. For the fourth factor on prejudice, what I would like to really hound on, Judge, is the fact that the boyfriend in the state's position, and as far as Ms. Pollock has not made very clear, is not a relevant witness to this case. Just because they were there does not make them a relevant witness. It's very possible we call him in and he doesn't recall anything either, just like her daughter could not recall anything, which in my opinion does not make them a relevant witness. Recollection of the defendants, and correct me if I'm wrong, doesn't count towards prejudice. It's if they are missing witnesses. Her daughter came in and testified today, which means she could come and testify at the trial. She doesn't recall anything. She doesn't recall anything. As I stated before, we have both detectives who found that there was enough evidence to move forward on this case and send it to the DA's office. They're willing to come testify, along with the victim who works for the trademark companies. He's willing to come testify. Additionally, these can be remedied. If they're saying they can't get a hold of that ex-boyfriend, with their permission, I would like to seek out this, I forgot his name off the top of my head, but her ex-boyfriend, and see if we can bring him in to potentially help defense with, getting rid of some of their prejudice. I do not dispute Ms. Pollock is correct that we now have the burden is on us to rebut the presumption of prejudice. But as stated, as far as where there was no pretrial incarceration here, there was no emotional distress because she claimed she had no idea she'd done anything wrong. And going toward impaired defense, as you saw, we have what? 1, 2, 3, 4, 5. We have 4 out of the 5 witnesses. I mean, that doesn't sound like an impaired defense to me. So, and I think if we were to redog it, and correct me if I'm wrong, Ms. Pollock, but I think there were actually missing witnesses in that case, and some evidence had actually spoiled. And I think that's what the court is looking at. If evidence has been spoiled or not preserved, or if we completely do not have some of the witnesses, not if their memory, isn't as good as it used to be, or if the case just was a certain length of time. That's why it is the first factor in Barker and not the most heavily weighed factor is the length of delay. If the court thought that that was so important, they would have made that one of the final factors and included that in the prejudice prong, but they did not. That's it, Judge.
Okay, defense motion to set aside information for failure to afford constitutional right to speedy trial. Clause 389841, State of Texas versus Blanca G. Alamán is respectfully denied. That being said, I would admonish the state to have a talk with their law enforcement agencies. I see no reason why this case should have gone this long. I don't know why the officers just didn't arrest her at the scene if they're going to do that anyway, and issue warrants later and whatnot. And I'm sure this type of case is tip of the iceberg for the police agency doing that. It sounds like they're just being lazy and don't want to take somebody down to the jail and book them. I'm not sure, but that would have resolved all the issues in this case had that been done at that time. I would also urge the state to consider pretrial diversion in this case very strongly, if that becomes something that could be considered. And Ms. Pollock, if it comes to it, you give our #1 jury setting, Ms. Benavides. If, as and when we ever get to have a jury trial again,
yes,
you get our #1 setting, whenever that's going to be. So that will not be a problem in that regard as far as the speedy trial from this point forward. Anything further from the state of the defense on Ms. Alamán?
Well, I did want to respond to the state's argument.
I've already ruled. If you'd like to continue talking and you can change my ruling, I'm happy to hear it. Go ahead.
Well, they argued that because Ms. Alamán might have had some knowledge that there was an investigation going on, she had some burden or duty to bring herself into court. That is the exact opposite of what these cases hold.
I agree.
Gonzalez, they specifically address that issue. Even if she might have had knowledge, that doesn't absolve them from bringing her into court to address these charges. And I would like to address in Doggett, they held that in certain instances, the length of delay may be so excessive that it presumptively compromises the reliability of a trial in ways that neither party can prove or identify. In such instances, the defendant is absolved from the requirement to demonstrate prejudice. It then shifts to the state to show that there was not prejudice. I would assert that they have not done that in this case. Because of the length of delay and the faded memories, we cannot present an effective defense in this case.
Judge, if I could just respond for the record. I'm not going to make Mike go back and read the transcript, but Ms. Pollock, if you would have been listening when I did state that she could have done something, I made it very clear that while she does not have a duty to do so, I did not misstate that. I did say that she does not have a duty to do so. However, if the main argument is that we're concerned about witnesses and all that, she could have. I mean, she could have, because one of the factors they say to look at is, did the defendant contribute to the delay? Yes. By not doing, she said that she knew something had happened. She stated that, she knew that there was supposed to be getting paperwork, but she never got it. So something could have been happened. And I do agree with you that there is no duty. Additionally, going back to the prejudice argument, when the burden shifts to us, I do believe the state has met its burden in showing that there was no prejudice. Going back to what you said, I mean, you just cited the case law saying if the defense or the state can't show prejudice. Well, you just said that if that's the case, well, then it needs to be dismissed. But then you said that you have shown prejudice and that I need to not show the prejudice. But right before that, you said neither party can show the prejudice. So that really doesn't make sense in itself either. And that's all I have, Judge.
Okay. Thank both the state and the defense for their time and their effort. I am not changing my ruling. It stands as previously stated. But once again, Ms. Pollock, if you, at your ability, discuss with your client other possible resolutions to this case, the court would be happy to assist the defense and the state in ensuring that she gets the kindler, gentler treatment under the circumstances of this case. So best of luck to everybody, and you're dismissed for the day.
We would also like everything to be included in the record in this case, including the trial brief and all the case law that.
Okay, I apologize. Can you say all that one more time for me? I missed some of that.
I would like the record to include our motion along with the trial brief that was filed, which sets out all the case law that I'm relying on in this case.
Absolutely.
Thank you.
All right, y'all dismissed. Thank you. We've got Mr. Goins back.
Yes, Your Honor.
Did you find
Yes,
Mr. Yes, sir?
Yes, Your Honor, and we're going to go off of one microphone so there's not too much background noise.
All right, let's take about a 2-minute break, and I'll be right back and we'll get this knocked out.
Thank you, Your Honor.
Arlene, we're finished. Thank you so much. Susan.
Pat.
Susan. Susan.
Yes.
Did they demolish?
Yes, they are done demolishing. They have cleaned and they
Wow.
they have left the property.
I need to find an electrician. I need to do that after I finish all of this stuff.
Seems like they did a good job. I mean, they cleaned up well, so.
Well, that's good.
Yep. So now we live with that for 6 weeks.
That's interesting, though, that they had to demolish it like that, but.
Well, because it had mold and stuff with mom's COPD. We wanted
Oh,
to treat
yeah.
it because see, it was open because they had to open it to cap the water.
Yeah, so they were working on making sure the mold and stuff was gone.
Yeah.
Dried out, probably. Dry everything out.
Yeah. So.
Oh, okay. Okay.
Time will tell. Slowly but surely it'll all